in some countries it's not controversial, because in some countries it seems already it's a law, and most people accept it. But in the United States, it's very controversial, and I imagine that in other countries it could also be extremely controversial. And so I'm talking about this this debate we have in the United States about same-sex marriage. Okay, the debate about same-sex marriage. And did everybody receive the outline? Okay, so I prepared the outline because for this lecture especially, I think there are some concepts, some terms that are very important to understand the debate. Okay, and one you see in the title of this lecture. I call this lecture Putative Constitutional Rights, the Role of Judges and Legislators in Historical Perspective. And so the lecture is about same-sex marriage, which can be described as a putative constitutional right. Now, does anybody know what I mean by putative here? What does this word putative mean? So it's like it's in doubt. It's in doubt. It's questionable. It's questionable. It's not widely accepted. Okay, putative means its status as a constitutional right is in doubt. Okay, so it means that people disagree. So if you call it a putative constitutional right, it means that there's a substantial amount of disagreement, that many people would say, no, that's not a constitutional right. Some people might say it is, or it should be a constitutional right, but other people will say, absolutely not. It's just not a constitutional right. So I call it the putative right to same-sex marriage because it's a debate. There's a big debate about this in the United States. And on the theme of rights in history, one reason why I decided to talk about this topic is that it shows you sometimes how the understanding of certain ideas related to rights might change. Okay, so there are questions here, very big questions about the American system of government, about who decides whether something will be a right and how something acquires the status of a right. And so I will be talking about that a lot in the next hour. Okay? When I ask the other question, how should we understand this putative right? What explains the national and international attention given to this matter? I think I can say a few things. You know, in the United States in the 1950s and 1960s, we had the civil rights movement. The civil rights movement so that the rights of black Americans would be fully respected. Okay? And the civil rights movement mainly was going on in the southern states because there was, in the 20th century, an important division in the United States between northern states and southern states, and many blacks were living in the South. Many blacks were living in the South, but their rights were not respected in the South until after the success of the civil rights movement. Okay? And after the civil rights movement ended, one could say that the movement for, so in the United States people call it simply gay rights, gay rights. The movement for gay rights began after the civil rights ended. In this movement for same-sex marriage, that really only began in the 1990s. I don't think that there was a serious movement for same-sex marriage before the 1990s. So we are talking about a movement for same-sex marriage that is maybe 20 years old. Maybe it's about a 20-year-old movement. Okay? And those people who wanted to create this movement for same-sex marriage, they had a strategy. They had a political strategy and a legal strategy. And this strategy was very simple. They wanted to bring this matter to courts instead of legislatures. Because they said legislatures, they will not like this idea. They will not like this idea, so we should try to be successful in the courts. And one reason they chose this strategy, one reason why they took this approach, was that most of the judges in the United States are liberal. Most of the judges in the United States are liberal and they are secular. Okay? And so the people who created this movement for same-sex marriage, they said, legislators will not like the idea, but maybe judges will receive the idea sympathetically. Okay? So this was, even if one is against the idea of same-sex marriage, this was a good strategy. This was a good strategy. And there's no doubt that this was the strategy, because today they talk openly about this, that they wanted to bring the matter to courts instead of legislatures. And maybe you know this famous observation by Alexis de Tocqueville. So de Tocqueville wrote this book, Democracy in America, right? And in my opinion, still probably this is the best book that was ever written about the United States. Tocqueville understood the United States better than most Americans understand the United States. And my theory as to why did Tocqueville understand the United States so well? So three things. One, he was European. Two, he was an aristocrat. And three, he was Catholic. Okay? So United States made up of Americans. We don't have an aristocracy. We never had an aristocracy. Our Constitution forbids anything associated with aristocracy. And three, as I said yesterday, the United States, the worldview is Protestant. Okay, there are a lot of Catholics in the United States, but the worldview of the United States from the time it was created is Protestant. So sometimes foreigners, when they come to the United States, they see things that Americans do not see. Okay, and Tocqueville saw the United States and understood the United States, I think, better than anyone. Better than anyone, because, as I said, he's European, he's an aristocrat, and he's Catholic. I give you one other example of this phenomenon. When the great Russian writer Alexander Solzhenitsyn moved to the United States in 1978, he was asked to speak to the graduates of Harvard University. So he gave this speech. This is a great honor to speak at Harvard University. It's called the commencement speech. And Solzhenitsyn gave the speech in 1978, and immediately it provoked a wide discussion among educated people in the United States. And still people read this speech today because Solzhenitsyn, in my opinion, he saw things in the United States that were very difficult for Americans to see. Very, very difficult. So Tocqueville said this. I get back to the main theme of the lecture. Tocqueville said, every political question in the United States sooner or later becomes a juridical question, a question for the courts. So every political matter sooner or later becomes a legal or juridical question. Okay? And so it seems that this controversy about same-sex marriage will be decided by the courts. It seems it will be decided by the courts, but there has already been a lot of legislative activity against it. And I will talk about that later. But probably the controversy will be decided by our national Supreme Court. Okay? And the prediction is maybe within 1 or 2 or 3 years, the Supreme Court will decide this case, a big case that's already in the federal court system, and maybe that will be the end of the controversy. But maybe not. It's very hard to predict at this time. Okay? Now, I want to talk about one other thing relating to this putative constitutional right. If maybe there is a right to same-sex marriage in the United States, it needs to be called an unenumerated right. So if you look at the outline, this is 1B, an unenumerated right. Now, does anybody know what that means? So this is the language of lawyers, an unenumerated right. And if I use this language in talking to most Americans, they would not understand me. Only people who know a little bit about the law
Not listed in the Constitution.
Exactly. Unenumerated means simply it's not listed in the Constitution. Okay? Just it's not listed. You do not find it. You do not find it listed anywhere in our national Constitution. Okay? Now there is a new development in American constitutional law going back to about 1965. So for 1B, I give the names of three Supreme Court cases: Griswold versus Connecticut, Eisenstadt versus Baird, and Roe versus Wade. Okay, these are three leading cases involved with the theory of unenumerated rights. In these three cases, even though they were decided in the 1960s and 1970s, these cases are still very controversial. They're still very controversial because they have to do with sexuality. They have to do with sexuality, and again, all of them involve unenumerated rights. So Griswold versus Connecticut and Eisenstadt versus Baird, they involved unenumerated rights for people to use and buy contraceptives. Okay? So Griswold and Eisenstadt involved unenumerated rights for people to buy and sell and use contraceptives. And Roe versus Wade, maybe you've heard of this case. Maybe today it's the most controversial case in the history of our Supreme Court. Roe versus Wade created an unenumerated right to abortion, okay, for the whole country. For the whole country. Now, why was this so controversial? Well, the answer is in 1C. This was controversial. These three cases were very controversial because, as you know, in the United States we have a federal system. And as I said yesterday, for example, the law of marriage is different from state to state. The law of marriage is different from state to state. And the reason it's different from state to state is that we say in our system of government that states, not the national government, but states have the police power. The police power. Now, does anybody know what this means, the police power? This is a term from British law, and because our institutions are based on British law, we essentially adopted it. What does the police power mean? Does anybody know? And sometimes you hear police powers, plural. Police power or police powers.
Municipal power.
What's that?
Municipal.
More specific. More
It's
specific.
a right to regulate.
Regulate
in
what?
terms of restrictions.
Good. A little more detail, please. So broadly it refers to this. Broadly it refers to this. Three things. Public health, public safety, and public morals. So in our federal system, each state exercises the police power, meaning each state can promote public health, public safety, and public morals as it wishes. There's only two restrictions on the exercise of the police powers in the states. The two restrictions are: a state cannot exercise the police powers in a way that goes directly against the national constitution, first. And second, a state cannot exercise the police power in a way that goes against its own constitution. Because you remember yesterday I said each state has its own constitution. So we really have 51 constitutions in the United States. So states have broad power, broad authority to exercise the police power, but they still must respect provisions, ideas in the national constitution as well as in their own constitution. Okay? But I go back to these three cases in 1B. Our national constitution says nothing about the subject of sexuality or marriage. It says nothing. And it's easy to understand why it says nothing. It says nothing about that subject because when the Constitution was created, it was understood that this was a matter for each state to make its own law. Do you understand? So the national government, the only time the national government really is going to make a law about marriage, as we saw yesterday, is when there is federal land, federal territory that has not been organized into states. Okay, so remember the case from yesterday about the Mormons in the federal territory of Utah at the end of the 19th century. So Congress, our national Congress, made a law for the federal territory that defined marriage as the union of one man and one woman. But Congress generally is not going to ever make a law about marriage for the United States, because each state will make its own laws. Okay, and so we saw this yesterday when we talked about the question, can first cousins get married, right? So some states allow it. Only a few states allow it. Most states prohibit it. And then you have strange states like Indiana, which allow it if the cousins are both over the age of 60. Okay? And so what you could say is when a state makes a law relating to marriage, about, say, first cousins, can first cousins marriage, the state is exercising the police power, so this relates to public morals, and maybe also public health, right? Because if you think one of the reasons why first cousins should not get married is genetic, you know, it's bad for children because maybe they will have birth defects, right? So maybe that's public health and public morals, okay? If the state says, we will not permit first cousins to get married in our state, okay? So I want to make just a simple comparison because, as I said a minute ago, almost all of our institutions in the United States, legal institutions, come from Britain. We have one state that has its legal institutions from continental Europe, and probably you know what that state is. What is it? We have one state that does not have British... Louisiana. Yes, Louisiana.
French.
Exactly. Yes, because Louisiana was a French property that we bought in the 19th century, and the legal system in Louisiana is still based on the continental European system. So this means if someone wants to be a lawyer in the state of Louisiana, that person should probably go to a law school in Louisiana, because if that person does not study the law at a law school in Louisiana, it will be very hard for the person to learn the Louisiana law, because its foundation is completely different. Okay, but all the other states have the British legal system as its foundation. And so, what does this mean? Well, it means also that Parliament in Great Britain also exercises police powers. But the British system of government is not a federal system, so Parliament exercises police powers for the whole nation, right? So it's just a simple point. The idea of police powers, it's part of British law. The difference is, in the United States, we have the federal system, so it's the states that exercise police powers. In Britain, it's Parliament exercising police powers for the whole country. Okay? Now, I just want to talk a little bit about the historical aspects of the law of marriage in British and American history. And this is not too complicated, so this is part 2 of my outline. Okay? And I need to say at the beginning something which I'm sure you all know. Marriage as an institution in the West, undoubtedly, it's based on the Christian understanding of marriage. Undoubtedly, it's based on the Christian understanding of marriage. So, you know, marriage is understood as the union of one man and one woman. It's not like Islam, where a man can have several wives. Okay, and this is something. If you think about Hegel, this is something that Hegel, I believe, wanted to emphasize in his political philosophy, that people in the West need to be aware of the historical roots of their freedom in their institutions. And, you know, Hegel, he did not really write so much about relationships between men and women, and it seems in some of the things that Hegel wrote, he had very low opinion of women. So, for instance, it's the beginning of the 19th century, and he could not imagine women being politically active. But if you read his section on the family in The Philosophy of Right, he believes that marriage is a very important public institution. It's a public institution that is based on the Christian understanding of marriage, and one of the things that he says is that divorce should be very difficult to obtain. Okay? Now that's a very Christian view, right? A very Christian view that in principle, this is what I write at the beginning, in principle marriage is supposed to be a permanent union between a man and a woman. This is the traditional Christian understanding. When you get married, it's for life until one of the spouses dies. That's the traditional understanding. And this, of course, has changed in the last 200 years. Really, it's changed since the French Revolution. Okay? One way it has changed is that now in the United States, so let me jump ahead a little bit. Now in the United States, we have a completely different understanding of marriage and divorce. So in the United States, we now have this thing called no-fault divorce. And this is against the traditional understanding of marriage, and it's against the traditional law of marriage, because the traditional law of marriage said that in principle marriage is supposed to be forever, but sometimes there are legitimate reasons for divorce, or legitimate grounds for divorce. And the three legitimate grounds for divorce in British and American law are listed in 3A. So the first is abandonment, the second is cruelty, and the third is infidelity. So abandonment means simply that one of the spouses just leaves. And it also could mean, it used to mean that if there was man and woman married, and if he did not support his family, so maybe he's living at home, but maybe he does not have a job and he does not want to get a job. So that was also considered abandonment, because the primary duty of the man in British law, the British law of marriage, the primary duty of the man was to support his wife and the family. Okay? So one ground for divorce was abandonment, as I just described. The second ground was cruelty. If either the man or the woman was unusually cruel to the other person, that would be a reason for divorce. And then the third, infidelity. So being, sexually intimate with another person besides your spouse. So those three kinds of behavior were grounds for divorce. But in the 1970s and 1980s in the United States, they introduced this thing called no-fault divorce. So no-fault divorce has to be understood against the traditional law of marriage. No-fault divorce meant that a man and a woman who are married, husband and wife, they can get a divorce really for any reason that they wish. Any reason that they wish. They just say, okay, so we don't like each other anymore. We don't love each other anymore, so we want a divorce. Okay? Now, many people in the United States think that this idea of no-fault divorce is bad. They think it's very bad because it made divorce too easy. And they think it's especially bad for making divorce too easy when the husband and wife have children. The idea here is that it's bad for children if their parents get divorced. It's bad for children because it creates some conflict in the family, and there are many complicated questions. Well, the children will live with the mother or the father, and what happens if the mother and the father, after the divorce, they live very far away from each other. So many people say now in the United States that no-fault divorce was not such a good idea and it should be changed. And so there are some legislative attempts now in the United States to change this policy of no-fault divorce. But most states still have no-fault divorce. Most states still have no-fault divorce, and I do not know. It's hard to predict whether no-fault divorce will change in the future. And this policy of no-fault divorce, it was introduced by state legislatures in the 1970s and 1980s. It was introduced by state legislatures gradually. And so probably by the end of the 1980s, almost every state had no-fault divorce. Okay? So what I am saying here about marriage in 2A is that marriage is both a private contract. It's a contract between a man and a woman. It's an agreement. Yes, it's an agreement that they will create a life together. And it's an agreement that is publicly regulated. It's an agreement that's publicly regulated. So there are, again, according to the traditional law of marriage, there are benefits for the husband and the wife, and there are also responsibilities or duties. Okay? So one thing that I mentioned here, this is the second point, the requirement of consummation. Requirement of consummation. This is a very important part of the law of marriage in Great Britain and the United States. And does anybody know what I mean here by the requirement of consummation?
They live together, earn together, spend together. Общее, we say it's хозяйство.
The common way of life, common econ. That's part of it, but consummation is something very narrow.
From consume?
Yes. No, it's the wrong. Consummation is an unusual word. Consummation, it means, yeah, okay, so it's a good word. It's a good word. I recommend you all learn it.
They eat together in the morning, afternoon, and the evening.
Not quite. No, consummation, so it has another meaning. If you say something has reached perfection, then it means it has reached its consummation. So what do you think this means for marriage, for men and women? So for it to be a legally valid marriage in British and American law, it had to be consummated. So how is marriage consummated, traditionally?
They meet, court.
After that.
After that, sleep together.
Yes, they must be sexually intimate. They must be sexually intimate, and the law was very specific about this. They must have intercourse. Intercourse. And I tell you this also, it must be intercourse without contraception. Without contraception. That was the traditional requirement of consummation. Okay? So it's an interesting philosophical question. Okay? So suppose a man and a woman, say it's the 18th century or the 17th century or 16th century. Suppose a man and a woman, they get married in a church in England, in some little village. Okay? And then after the wedding, and so before the wedding there has been no sexual intimacy between the man and the woman, okay? And then after the wedding, suppose there's a terrible accident, okay? Maybe they're in some carriage drawn by a horse, and it goes off the side of the road, and maybe the man, he has a very bad injury, extremely bad injury, so for the rest of his life he cannot walk normally, and he cannot take care of himself. And suppose also he cannot be sexually intimate with his wife. Okay? So suppose this happens after the church wedding, but before they have sexual relations. So the question is, according to British law, are they legally married? Are they legally married? And the answer is no. The answer is no. This, of course, is a great tragedy. It's a great tragedy that there was this accident and that the marriage was not consummated, that they did not have sexual relations. But the answer, according to British legal sources, many British legal sources, many cases, no, they're not married, because the requirement, the absolute requirement of marriage is that there must be consummation through sexual intercourse. Okay? The other requirement, this is very important also, the other requirement is that both the man and the woman must consent to marriage. So many people say this today when they read about marriage. They say, well, of course, for many centuries, all marriages among rich people were arranged. Okay? So the woman never had a choice. Her parents decided for her. But I do not think this is correct in the British and American legal system. In the British and American legal system, the woman had to give consent. Now, maybe her parents want her to marry someone. Maybe, you know, he's from a rich family and she's from a rich family. So they say, we really want you to marry this man. We think he's a good man and he's from a good family. But the requirement in the church wedding was she must say yes. Yes, this is my free choice. I want to marry him. And he must say, yes, this is my free choice. I want to marry her. Okay? And some scholars today, when they write about marriage and they write about the status of women in the West, they say this was very, very important because it recognized women as independent moral agents. That this was her choice, and if she did not want to marry, at least in theory, she could say, no, I will not marry this man. I would not marry this man. And in the church wedding, there's always a point where the woman is asked, you know, do you take him to be your husband? Do you want him to be your husband? And it's a free choice, according to the law. It must be a free choice, otherwise it's not a valid marriage. So those are the two historical requirements for a valid marriage in British and American law. Consent, free consent, and sexual consummation. Okay? I stop for a minute. Any questions or comments on what I'm saying now? Clear enough? Okay, so I continue. Okay. I make one other comment about the law in the United States. So if you go to 2B, as I said earlier, we have this federal system, and this allows states, at least historically it allowed states, to experiment a little bit with marriage. Experiment a little bit. So you still always have those two requirements I just described, but states can experiment a little bit, as the example of first cousins shows. And there was a famous justice of the Supreme Court, a famous judge on our national Supreme Court. His name was Louis Brandeis. Louis Brandeis, he lived in the 19th and early 20th century. And Louis Brandeis said that states in our federal system, he said they are little laboratories of democracy, meaning states can experiment with different policies especially relating to public health, safety, and morals. So one state might say, for example, I do not think it's a problem if first cousins marry. I mean, I do not think, we do not think in this state this will be such a bad problem, so we will allow it. And if there are some bad consequences in the future, maybe we will change the law. Okay, so they are experimenting a little bit. They are experimenting independently as a state, but they are also experimenting in a way so that other states can maybe learn from them. Right? Other states could look at what they're doing and say, oh, that's a good idea. Maybe we will try the same thing, or maybe not. Maybe the other state will say, no, the consequences are bad, so we will not do what that state did. So that's the idea of states as laboratories of democracy. And one thing that happened because of these three decisions I list in 1B, Griswold versus Connecticut, Eisenstadt versus Baird, in Roe versus Wade, one thing that happened was that the Supreme Court, so we say it nationalized these matters. Okay? Another way of saying that is that the states after these three decisions could not make their own policies. They were obligated to accept what the Supreme Court said. So one could say after those three decisions, the states could not experiment anymore with policies in these areas. Okay? Now this is very important for the current debate about same-sex marriage, because what some people say today in the United States is, look, a few states are allowing same-sex marriage. And some people say same-sex marriage, it will have bad consequences. But other people will say, okay, but it's a federal system, so some states can experiment, and then everybody can learn from those experiments. Some states are now allowing same-sex marriage, and maybe if there are bad consequences in the future, those states can change the policy, or other states can learn from those policies. But the worry is, if you like this idea of the states being laboratories of democracy, the worry is that if the Supreme Court nationalizes this issue and says that every state must allow same-sex marriage, that it will be a very serious consequence for the integrity of our system, for the integrity of our federal system. Do you understand what I'm saying? This is maybe the most important legal dimension to this controversy about same-sex marriage. That if the Supreme, because there's an important point here. If the Supreme Court says every state must allow same-sex marriage, it means that states cannot prohibit it. Yes, so it's like a requirement from the national Supreme Court. Every state must allow this. But it's possible that the Supreme Court will say the other thing, which is it's a decision for each state to make. It's a decision for each state to make. So you understand this. The Supreme Court will not say, so we call this is an important idea, we call this an asymmetry. And this is like an asymmetry. The Supreme Court might say, every state must allow same-sex marriage. But the Supreme Court will not say, every state must prohibit same-sex marriage. And this is simply because of the way the law has developed, right? So as I said, now I think we have 5 states that are allowing same-sex marriage. But the case that's in the federal court system now, the case that's working its way up to the Supreme Court, the national Supreme Court, it's a case involving California. And maybe you heard about this. So in California, 2 years ago, there was a referendum, and it was called Proposition 8. Proposition 8. So it was a referendum for the whole state. Anybody in California who was registered to vote, this was in 2008. 2008, the same day that we had the presidential election. Okay? Election day 2008. The citizens of California voted on Proposition 8. Proposition 8 said that marriage in California will be reserved to the union of one man and one woman. Okay? And Proposition 8 was successful. It was successful, and immediately after the people found out that Proposition 8 was successful, a lawsuit was brought against it. And this lawsuit is now in the federal court system, and it's going all the way to the national Supreme Court. And so when the national Supreme Court decides whether Proposition 8 is constitutional, it might say that all laws in every state against same-sex marriage are unconstitutional. Do you see this? Mm-hmm. It might say every state, it might say Proposition 8 and similar laws are all unconstitutional, so every state must allow same-sex marriage. But what the Supreme Court will not say, it will not say that every state must accept marriage, the traditional definition of marriage, as the union of one man and one woman. It's because Proposition 8, the legal attack on Proposition 8 says that Proposition 8 is going against our national constitution on the idea of these unenumerated rights, these unlisted rights, these 3 cases in 1B having to do with human sexuality. Okay? So I tell you just a little bit more about the legal situation right now in the United States. So if you look at Roman numeral 3, I list two more Supreme Court decisions. One case was called Bowers versus Hardwick. This was 1986. And the other case was called Lawrence versus Texas. This was 2003. Now, Bowers versus Hardwick was decided in 1986, and the case is related to the three cases in 1B. Because Bowers versus Hardwick, it was a constitutional question involving rights of homosexuals. So in 1986, approximately 25 states in the United States had laws that made it a crime for male homosexuals to have sexual relations with each other. Okay, so in English we say this is anti-sodomy law. Anti-sodomy law. And probably you know the word Sodom that comes from the Bible. Okay, so in 1986, approximately 25 states had laws making it a crime for two men or more than two men to have sexual relations with each other. And in this case, Bowers versus Hardwick, two men said that they should also have an unenumerated right to sexual freedom on the basis of the three cases in 1B. And in 1986, the Supreme Court said, no, you do not have that right. You do not have that right. Homosexual behavior, it's different from the behavior in these three cases that came before 1986. But when Bowers versus Hardwick was decided, so almost immediately after Bowers versus Hardwick was decided, many scholars started to criticize it. Many scholars started to criticize it, and they wanted to bring another case in the future. They wanted to bring another case in the future, and they were hoping that the Supreme Court would putative, rethink the matter, change its mind. Okay, change its mind, and that's what happened. That's what happened in this case, Lawrence versus Texas, in 2003. Okay, now this is interesting. In 1986, as I said, 25 states, approximately 25 states, had these laws making it a crime for men to have sexual relations with each other. In 2003, only 9 states had such laws. So the legislatures in most of these 25 states, they changed their minds. They changed their minds, and so 16 of them, approximately 16 of them said, we don't think that it's necessary to make this a crime anymore. It doesn't seem to be such good legislation, so we will take this law and eliminate it. Okay? But you still had 9 states, including Texas, that had the law. But in 2003, in Lawrence versus Texas, the Supreme Court said, we made a mistake in Bowers versus Hardwick, and this too is an unenumerated constitutional right. Okay? So here again, the Supreme Court nationalized the issue, and it was telling those 9 states, you cannot use the police power. You cannot use the police power to pass laws on this subject. Okay? So now, obviously, because of the Lawrence versus Texas decision, this is not a crime in any state. Okay? The next development, the next important development after Lawrence versus Texas took place in different states. It took place in different states, and it was involving state Supreme Courts. Not our national Supreme Court, but state Supreme Courts. Because, as I said yesterday, every state has its own constitution. And after Lawrence versus Texas, some state Supreme Court said that there is a right for persons of the same sex to marry on the basis of their state constitution. Okay? So I tell you one other thing about the Lawrence versus Texas decision. In Lawrence versus Texas, the Supreme Court said it was not giving any opinion about whether two persons of the same sex can marry as a question of national constitutional law. It said, we are not going to make any prediction about this. We're not going to, at this time, give any opinion about that. This is just about these anti-sodomy laws. Okay? But several state Supreme Courts, including the state Supreme Court in Massachusetts, within 1 year after Lawrence versus Texas, the state Supreme Court in Massachusetts said there is an unenumerated constitutional right in our state constitution. In our state constitution, allowing persons of the same sex to get married. And so now I think 5 state Supreme Courts have said there is this unenumerated constitutional right according to their state constitution for same-sex marriage. Okay? So that, in general, is the legal discussion. If you look at the last part of my outline, I want to talk a little bit more about the political discussion that's taking place in the United States. So I call this section some disputed questions. And so the first group of disputed questions, 4A. And you hear this a lot today in political discussion in the United States. Some people will say that the movement for same-sex marriage is an extension or a continuation of the civil rights movement. And then other people will say it's not. It's not a good analogy. Historically, there's no real connection between the movement for same-sex marriage and the civil rights movement. And one thing that some people will say is the big difference is that black people in the South, they did not have the right to vote. In theory, they had the right to vote, but never were they allowed to vote in southern states in the first half of the 20th century. And people will say the difference is that persons who are homosexual, they still have the right to vote. They have the right to vote, and they can, if they want to have same-sex marriage as a policy, they can go to the legislature, they can publicize the movement, they can try to persuade legislators and voters that same-sex marriage should be approved legislatively. Okay? So that's one part of the national discussion. The second part already I talked about a little bit, and the big question is, will it be bad if the Supreme Court says that there is an unenumerated constitutional right to same-sex marriage for everyone in the United States, that is for all 50 states? Would it be bad? And the answer to this question, I think, depends on a person's attitude towards same-sex marriage as a new social policy. People who are in favor of same-sex marriage generally say, yes, it would be a good thing for the Supreme Court to decide this question for the whole country. And then people who have some doubts about same-sex marriage, they will say, no, in general, this should be for each state to decide. This should not be a matter for the Supreme Court to nationalize. Okay? And then finally, part C. And this is looking to the future. And of course, I am not a prophet. I cannot predict the future. But these are some other things that people are talking about now. And this is quite interesting because when I said earlier that maybe this controversy is going to cause problems for the integrity of the whole federal system, this is what I have in mind. Some people right now are saying that if the Supreme Court nationalizes this issue, that some states will refuse to implement the law. Okay? Now how could states do this? Well, maybe you know this. In the United States, and I think in most of Western Europe, most homosexuals, they live in big cities. So in the United States, some small states and some states in the middle of the country, this is not an important issue for them. And probably there are very few homosexuals living there. Okay? So for example, states right in the middle of the country and states in the north near the border with Canada. Okay? So it's easy for me to imagine, I am not predicting this, but it's easy for me to imagine that if the Supreme Court says there's an unenumerated right to same-sex marriage throughout the country, some of these states in the middle of the country will say, we don't accept it, and we're just not going to do it. We're not going to do it. And so this would be a very strong criticism of the Supreme Court, And then the next question would be, well, what would the Supreme Court do? What would the Supreme Court do? What would the national government do? And here, maybe we can try to predict what will happen from the history of the civil rights movement, but I don't think it's easy to predict, because the difference is, during the civil rights movement, many southern states, of course, did not want to give blacks, did not want to respect fully the rights of blacks. So they really did not want to let blacks vote. But there were so many blacks living in southern states that it was easy for the federal government to say, this is a matter of national importance. Many blacks are living in the South. So the federal government sent federal army to southern states to say, you must do this. You don't have a choice anymore. You don't have a choice anymore. The rights of blacks are enumerated in the Constitution. You look at 13th, 14th, and 15th Amendment to our Constitution, they all involve the rights of blacks, newly freed slaves. Okay? So it was easy for the national government to say, you must do this. It's a national policy now. Yes, each state has a lot of discretion, a lot of authority, broad authority to promote public health, safety, and morals, but the rights of blacks are protected by the 13th, 14th, and 15th Amendment. Therefore, we are sending the national army in so that you respect the rights of blacks. But if the Supreme Court nationalizes same-sex marriage, one of the problems is that people in different states who might be against this, they can say, look, it's not in the Constitution. It's not in the Constitution. You, the Supreme Court, have created, you have invented a new right. It's not in the Constitution, and it's really for each state to decide this matter. Okay? So it is possible, and people are talking about some states resisting the Supreme Court, the national Supreme Court, if the Supreme Court nationalizes this issue. And then finally, there's a big theoretical question here, which I think is for people in countries where there is a written constitution. Because the last question I ask is, when interpreting a written constitution, do the views of a court take precedence over the views of a legislator or executive officer? What do I mean by this? I mean, when our Supreme Court interprets our Constitution, is that the final or definitive interpretation? Of course, the Supreme Court, the National Supreme Court, wants to say yes. We're a court, and if we interpret the Constitution, our interpretation must be the final interpretation. But some people say no. Some people say it is possible that the Supreme Court might make a very big mistake, and it's possible that legislators and the president might tell the Supreme Court, no, you made a big mistake, and we will not accept your decision. The other thing that can happen in a federal system is that individual states can tell the Supreme Court, you made a big mistake, and we, the people of the state, refuse to accept your decision. And this could, again, I'm not predicting this, but it's possible, this could create a constitutional crisis. This could create a constitutional crisis if the Supreme Court, our national Supreme Court, said one thing and people in different states refuse to accept that. Okay? And this really, I think, could happen in any country that has a written constitution where the judges are regularly interpreting the Constitution, and where the judges especially are creating new rights, that is, unenumerated rights, rights that are not explicitly mentioned in that Constitution. Okay? So I stop here. Do you have questions, or is there something maybe you want to discuss about this?
Make a couple questions.
Sure.
I don't understand exactly what you mean by saying that states would resist the Supreme Court. Isn't it binding?
That's the question.
No, wait,
look,
is it a question?
yes, it is a question.
Why is that? as far as I understand, the Supreme Court says what Constitution says.
Yes.
Is that correct? So they are not supposed to resist Constitution. They can resist, they can discuss the question, but they should obey Constitution, and so they should obey what the Supreme Court says. Is that correct?
Maybe, maybe not.
Why not?
Because what you're talking about is this, and this, you know, this is a subject that it's very important now in American constitutional law. The idea is judicial supremacy. Judicial supremacy. What does judicial supremacy mean? It means that when interpreting the Constitution of the United States, the Supreme Court has the final or definitive. You know this word, definitive.
Yeah.
Okay, so does the Supreme Court have the final or definitive interpretation of the United States Constitution? Some people say no. Some people say no.
What's the basis for that position?
Because
who is then the last instance?
The last instance?
Yeah.
Okay, so there's a famous case in the 19th century. Okay, one of the most famous cases in the history of our country. Maybe you know about this. So this was a case decided soon before our Civil War. Soon before our Civil War. Dred Scott was a slave. Dred Scott was a slave, and he was spending time in a free state. Okay, so he was a slave. His owner was living in the South, and then his owner went to the North in a free state. And the law in most states was, if a slave was spending a lot of time in a free state, then he became free. Okay. So Dred Scott, he's in the North, and he's living for a long time with his master, his owner, and the master says, I want to move back to the South, and Dred Scott says, well, we've been here for a long time, so you should free me, because you know this is the law. And the man said, no, I'm not going to free you. And so Dred Scott sued for his freedom, and the case went all the way to the Supreme Court of the United States. And the Supreme Court of the United States ruled against Dred Scott. And the ruling, it's a very long ruling. It's like a book. It's like a novel. Okay, it's about 250 pages. Okay, and you read the case today. And you just say there are so many mistakes here, so many historical mistakes in the Supreme Court's ruling. And the very interesting thing is, at that time, 1858, Lincoln, who became president in 1860, Lincoln was senator from the state of Illinois. And Lincoln said, in a very famous speech, he said, okay, so I understand the Supreme Court issued a ruling against Dred Scott. And Lincoln said, you know, it would be impossible for Dred Scott to, at this point, rebel against the ruling, to rebel against his owner. So Dred Scott, it seems, must accept his fate. But, Lincoln said, there are so many mistakes in the Supreme Court opinions that the President in the Congress should not be obligated to respect the full opinion of the Supreme Court. So Lincoln then is going against this idea of judicial supremacy because many people said after Dred Scott, after this case, well, Supreme Court, of course it has the definitive interpretation of the Constitution. Of course everybody must accept what the Supreme Court says. But Lincoln said, no, if there are many mistakes there, then the President and the Congress are not obligated to accept the decision. Okay? Now this is a complicated legal matter because I believe most Americans would agree with what you first said. Of course, we must all accept the idea of judicial supremacy. If the Supreme Court decides a case, everybody must accept the case. What I am suggesting against the idea of judicial supremacy is the possibility that sometimes a ruling of the Supreme Court can be against the Constitution. A ruling of the Supreme Court can be unconstitutional.
You cannot say something is against the Constitution or against any law. You're not an instance. And Lincoln was not an instance. And
I'm sorry, I didn't understand. Lincoln was not what?
An instance. An organ, an official, an authority to decide.
No, okay, good.
It's not
good.
an authority.
Very, very good. I'm glad you say that because I think it's more complicated than that. Lincoln said this. Lincoln said, well, I am a senator from Illinois. I am a senator from Illinois, and a requirement for everybody who is in the Congress, the president and every member of the Congress in the United States, the Senate and our House of Representatives, before they take their office, they must swear to be faithful to the Constitution. And Lincoln said this. Lincoln said, look, every legislator in the United States must swear to be faithful to the Constitution. The president also swears to be faithful to the Constitution. So they also have an obligation to respect the Constitution. And if the Supreme Court makes a mistake, legislators and the president have an obligation to describe that mistake.
That's understandable, but who is the authority to say it is a mistake? We do not have that authority. If we don't have authority, we just take it for granted, or we take it without doubt that the Supreme Court doesn't do mistake. It's an axiom.
I disagree. I disagree, but it's very complicated. I understand what you were saying. I understand what you're saying. So how are these questions resolved? Well,
you don't have authority to resolve that, because Supreme Court has a higher, or the highest authority. So we do not have an authority to define some action as a mistake.
It's an interesting point, but the only way.
We can do it theoretically.
So think about this. Think about this. Okay. So we will try to imagine. We'll try to imagine the future. Okay. This is a good exercise, I think. So imagine the Supreme Court. Imagine the Supreme Court says every state must allow same-sex marriage. Okay. And imagine, as I said a few minutes ago, some states are against this. Some states in the middle of the country, they are against this. And they say, well, we refuse. We refuse. We're not going to do this because we think you, the members of the Supreme Court, have made a big mistake. You do not understand the Constitution correctly. Mm-hmm. Okay? Now, the next question is, well, what is the national government going to do? What's the national government going to do? Suppose it's one state. Suppose it's only one state that says, no, we don't accept this. I do not know what the national government would do. Suppose it's one state in the middle of the country where there are very few homosexuals living, so very few homosexuals are even applying for a marriage license, right? So the difference between this and the civil rights movement is, during the civil rights movement, it was easy for the national government to say, this is a huge issue. It's an enormous issue, and the national government said, we are sending in federal army troops, okay? But here, it's almost impossible for me to imagine that the national government would send the army, the national army, to one state in the middle of the country if there are very few homosexuals living there. So do you see this? Now imagine it's several states. Imagine, say, it's 5 or 6 states. Well, if they say openly to the Supreme Court, you made a mistake and we refuse to do what you say, then the possibility is the Supreme Court might rethink its decision. It's possible the Supreme Court might rethink the decision. And this might not happen immediately, it might take a few years. And then the possibility is the Supreme Court might admit that it made a mistake. Okay? So it's very hard to predict if there is some kind of resistance or opposition, what the next development would be. But I give you an analogy with yesterday. Remember yesterday we're talking about the Reformation. We're talking about the Reformation, and we're talking about Luther and Calvin. And the law in Europe at the time was, if the parents are Christians, the children must be baptized. And the Anabaptists said, no, we've thought about this for a long time, and we are not going to obey the law. And Luther and Calvin said, no, you must obey the law. This is the state. This is a policy of the state. And you are Christian, and it's your obligation as Christian parents to baptize your children. The law says this. Well, what did the Anabaptists do? Well, they protested, and they were willing to be persecuted. They suffered persecution for about 15 or 20 years, and because the Anabaptists said, this is an extremely important principle for us, finally Luther and Calvin, they changed their minds. So there is this possibility, if there is opposition and active resistance, there is this possibility that some institution might change its mind. You see my point?
I understand your point. Well, I know we don't have time.
But if you want to...
if it's possible, I just say my position. Your arguments doesn't do anything against my position. I think you just mixed different argumentations. You say what would happen. So you mix legal and factual first, and second, if you say that some authority will change its mind, it still doesn't go in, doesn't undetermine my position, because it would be the authority who is changing its mind. So we are not undermine the whole structure of hierarchy of authority.
Okay, good. So it's a good response. It's a very good response. The only so
I'm sorry. Legal system cannot solve all the problems, but it has some logic we're supposed to obey. If we obey the whole logic, we should obey the particulars.
So I tell you this, I mean, it's a very good response to what I'm saying. It's a very good counter-argument to what I'm saying. And you will be pleased, many of my students, they agree with you and not me. So I introduced this matter to them, and many of my students think I'm crazy, okay? They think I'm some kind of troublemaker, radical, anarchist, okay?
Could you clarify one more point? Here's my second question. You were talking about the Supreme Court's decision against anti-sodomy laws, state laws. What were the argumentation, and could it be the basis for the enumerated right for same-sex marriage?
Exactly.
So is it already stated in the decision, or it's not?
Well, in this case, Lawrence versus Texas. Lawrence versus Texas is on the outline. That's the case. The Supreme Court said those 9 states that still have anti-sodomy laws, they must change their laws because anti-sodomy laws are against the Constitution. Okay, but in that case, in Lawrence versus Texas, the Supreme Court said openly, we are not now going to say anything about the question of marriage between 2 persons of the same sex. Supreme Court in that case said, we're not offering an opinion, we're not offering a prediction, we're saying nothing about the question about same-sex marriage. So, okay. Anything else?
I have one question,
Sure.
but after the break.
After the break. Okay, that's fine. So worse than a man raping a woman. It's worse than a man raping a woman. And this is so shocking to us, it's almost hard for us to imagine what they have in mind. But in my interpretation, what it means simply is, if a man has sexual relations with a man, according to Christianity, that's worse than rape, because if a man rapes a woman, at least it means he still has like interest in woman. If a man is having sexual relations with a man, he has no interest in women, and it shows almost great contempt for women. Do you understand my point? Now, I am not exactly sure that that's the idea, but this is what it said in some very old British cases, that sodomy is a worse crime than rape. Okay, and I think that must be because of the Christian influence, even if it seems strange to us today.
The Christianity was able to legislate itself into law.
Yes, yes. I mean, if you look, even if you are not religious, and if you look at Christianity as a religion and as an influence on the West, historians will say Christianity had some immediate consequences. So one thing that Christianity did in the Roman world is it brought to an end the practice of infanticide, right? So Romans routinely, if a baby was born that was very sick, Romans, they'd leave it on the hill and just let it die. And Christianity said, no, every person deserves respect. Okay, even a person that's born with very bad injuries, or we say birth defects in American English. And Christianity brought an end. So the word infanticide. Infanticide. So you kill a little baby. A baby that's just been born because it's not healthy. Christianity said, no, you must not do this. And when Christianity became the official religion of the Roman Empire under Constantine, that practice stopped. So that was one thing. And then the second thing was relating to sexuality. Many things relating to sexuality that were common in the classical world, in the world of ancient Greece and Rome, these ended. And during the break we were talking about, in classical Greece, the normal relationship for a man was to have sexual relationships with a boy, right? So the ideal situation was for a man, maybe 30, he's 30 years old or 40 years old, and he has regular sexual relations with a young boy, maybe 13 or 14 or 15. And this today, I mean, this is considered in the West, it's considered a shocking crime. If an older man had sexual relations with a boy who was 13, 14, or 15, this is considered terrible. And so it's an interesting question. If same-sex marriage becomes more common in the West, what will future developments be? Again, I cannot predict, but the difference between traditional Christianity and the morality of ancient Greece and ancient Rome, the differences are important. So, someone else, question here?
I just wanted to point out that this problem is not political, not political, and that
it's not political.
It's not only political.
It's not only political. Safety and morals, right? Yeah. So that's the federal system, and remember what I said. So states have broad authority to promote public health, safety, and morals. The two requirements are when they pass legislation to promote public health, safety, and morals, they must respect the language of the national constitution and the language of their own constitution. The originals would say, show me where the right to same-sex marriage is in the national constitution, and say you can't show me because it's not there. And the originals would say that's the end of the discussion, right? Yeah. The originals would say the same thing about abortion. The originals would say, look, abortion, each state must decide. Each state must decide because the Constitution, the national Constitution, says nothing about it. Okay, and then so postmodernist or new liberal approach to reading the Constitution. Now those are the people that generally favor unenumerated rights. Yes. So you are correct. The legal question, the juridical question, may depend in the end on the interpretation. Yes, on the interpretation of the Constitution, the interpretative theory that a judge accepts. So very good. Yeah, that's good. Anything else? Any other questions on this or comments on this? Does everybody understand what I mean by reparations? Do you know this word in English? Okay, so yeah, reparations or compensation. So the word reparations, I think it's related to the word repair in English. So if something's broken, you fix it, you repair it. And I believe that the root of the word reparations is the same root as the word repair, the verb repair. And what about gross? Do you know what I mean by gross here? For gross human rights violations. So gross means extreme. I don't know, how would you say it? Shresvichayny. Yeah, so like extreme human rights violations.
Essential.
Gross here means very bad. Yeah. Crime, extreme, yeah, crime. Yeah. Okay. So this is the question: Should there be reparations for gross human rights violations? And I am interested in the legal dimensions to this and philosophic aspects of the question. And I think also this raises many interesting questions about how we understand rights, how we understand individual rights. And I want to make some observations in the first part of the lecture by asking asking question: why would anybody be interested in reparations? And I think the answer is simple. It's just a belief that there is some injustice in the past that needs to be resolved. There is an injustice in history that deserves our attention today. And people might disagree. People might strongly disagree about two things. They might first disagree about whether there was, in fact, an injustice. Okay? And two, they might disagree about whether that injustice deserves our attention today. Okay? Because, of course, there are many injustices in history that we think are so far in the past, so far from us, that we cannot spend time thinking about them, or that we cannot spend time thinking that maybe we can resolve the injustice today. Okay? Some of them, if you asked me, for example, do I spend time thinking about the injustice of slavery in classical Athens? Well, the answer is, well, I read about it, and of course I think about slavery as an institution and as a historical problem in classical Athens, but I do not think so much about this as a contemporary problem. So I give you another example related to this. Imagine there was a Greek person who knew. Now this is a silly example. Okay, it's not a serious example, but I use it anyway. Imagine there's a Greek person who knew his family history going back to centuries before Christ. Okay, so he knew his family history going back to the time of classical Athens. And imagine this person knew that he had relatives in classical Athens who were slaves. Okay? He knew the complete family history from the time of Pericles to the present. Okay? And he could demonstrate, maybe he had some document, yes, my ancestors during the time of Pericles were slaves. And so he had these documents, and he said, I will go to the Greek government today, and I will demand reparations. Well, I think most of us would say this is just so far in the past that we cannot take this seriously as a matter for legal resolution. Okay? Now the example is silly because I think it's impossible to imagine somebody that has such a great knowledge of his family history. Okay? Because we're talking 2,500 years almost. Okay? So it's a ridiculous example, but I use it to make the point that when we go back in history, at some time we say to ourselves, the matter is too far in the past to be resolved today as a question of justice. Okay? But I say this, there are things that happened in the 19th century in the West that are still being discussed today. So reparations in the United States largely involves the question of slavery. And there are many black Americans in the United States who know that their ancestors living in the 19th and even 18th century were slaves. They have documents, they know about the family history in a way that's, I guess, very surprising. I mean, they know so much about the history, I think, because it was considered important to record the family history because of the oppression and the injustice. And they could prove, some of them could prove, yes, my ancestors were slaves. And they say, some of these black Americans, they say, we deserve compensation. We, living today, deserve compensation for the crimes committed against our ancestors, for the fact that their human rights were violated. Okay? So to talk about 100 or 150 years, in my opinion, it's not absurd, it's not ridiculous. To talk about 2,000 or 2,500 years, then I think you say it's just too far. It's too far in the past. Now, where is the border? I don't know. I really don't know. I cannot give an exact answer to that. But maybe we talk about that later. The point that I'm trying to make in 1A is that reparations, usually when there is a discussion about reparations, we are talking about reparations for extreme human rights violations. And so there's an interesting article. There's an interesting article by a political philosopher. His name is George Kateb. And he wrote an article called On Political Evil. On Political Evil. And what he tried to do in this article is to argue that there are important distinctions between bad states or bad regimes. And so the worst regimes, or the worst states, he calls evil. He calls evil. So what does an evil state do? Well, Kateb says an evil state is involved in gross human rights violation, including things like genocide, slavery, maybe you've heard this phrase, ethnic cleansing. Okay? An evil regime does things like that. So what would be examples of an evil regime or an evil state? Well, obviously Nazi Germany. Okay, obviously, an example, maybe the best example of an evil regime. And I don't like to say this, but it's true. I mean, well, maybe you say, yeah, I think Soviet Union under Stalin, right? Soviet Union under Stalin, because of so many people being killed or imprisoned.
China in 50s, 60s.
Cultural Revolution. Yes, yes. Okay. And so I give an example from American history, and I wish this were not true, but it is. Slavery in the United States, in the southern states before the Civil War. I mean, it's just today you read it. You read about the history. I read about it as an American, and it's like a source of shame for me. It's a source of shame for me because you look at the ideals in the Constitution and in the Declaration of Independence, and you ask yourself, well, why did our country allow slavery? And why in the 19th century, why did white people in the South, why did they defend slavery? So aggressively. So I regard slavery in the South before the Civil War, I regard that as evil. Now, what about oppressive? What is an oppressive regime? So here I would say an oppressive state is a state where there are many injustices and the atmosphere is unfree. The atmosphere is unfree, and people are worried almost all the time about their rights being violated. So people have to be very careful so that their rights are not violated. So what would examples be? So maybe many South American countries in the 1960s, 70s, and 80s under dictatorships. So for example, Chile under Pinochet. So many human rights violations, and in general an atmosphere of the environment was fear. Many people worried about being arrested and persecuted by the Chilean authorities when Pinochet was in power. Another example would be, I think, in the 20th century in the United States, in the South, when we had segregation. So blacks at this time, they are not in a condition of slavery, but their rights are not being respected. They cannot vote. They have almost no political influence, and many of them are living always in a state of anxiety. They're always worried about some persecution. Maybe it's some persecution from the state, or maybe it's some popular persecution from people who are not associated with the state, right? So white people going against a single black person, for instance. So you probably know about this, black people being being lynched, just killed without a trial. Sometimes black people committed a crime and they were lynched. Sometimes it was just a rumor or some suggestion that a black person committed a crime, and so sometimes they were killed or hurt without a trial. So that would be an example of an oppressive regime. And then an unjust state or an unjust regime, I think, is a state where there are many injustices, but there is not an atmosphere, a widespread or universal atmosphere of anxiety. And this raises the question, in my mind, are there any states where there is perfect justice? And probably the answer is no. Probably the answer is no, but I think there are some states in the world where there are very few injustices, right? So, I look at a country like Helsinki or Finland. Finland is a small country and it's a very stable country. And I don't know, I mean, you just don't really read about great political crises or legal crises in Finland. Maybe it's a boring country, but maybe it's a good thing to live in a boring country. Do you understand? So it seems very stable. I am sure that there are some injustices in Finland, in Scandinavian countries, and in some of those countries in the world that are very stable politically and legally, right? So maybe in Central America, one of the most stable countries is Costa Rica. I think Costa Rica does not even have an army. And it's a very unusual country because all around it are these unstable countries with very bad human rights violations historically. And then there is Costa Rica. It's stable, no army, and no atmosphere of anxiety, no great number of injustices. Okay, but most states have a large number of injustices, and a state can have many injustices, but it can be a reasonably good state if there are mechanisms, if there are procedures for those injustices to be addressed, to be resolved. Okay, but I still think that this essay by George Cative, it's a useful essay because he says make distinctions between evil states and oppressive states and unjust states. Okay, I think that's useful. And when you talk about reparations, I think usually you are talking about states that are oppressive or states that are evil. You're talking about political and legal crimes of a very high degree. Okay? Now, there's one other thing I mentioned here, and maybe you know about this man. It's interesting because this man, he became a lawyer in the United States, an international lawyer, but he was actually born in the Ukrainian city of Lviv. This man, Raphael Lemkin. And Raphael Lemkin, according to most scholars, he invented the word genocide in English. And I tell my students this, and my students, for one of my courses, they read a little bit about Raphael Lemkin, and my students, they did not know that this word genocide is a 20th century word. It came about exclusively because of Lemkin's attempts to draw the world's attention to genocide as a political and legal problem. So genocide is, of course, evil, and reparations, as we shall see in a few minutes, reparations often is in response to genocide. It's often in response to the crime of genocide. Now, I want to make quickly just a few analogies, a few legal analogies that help to explain the idea. When people, when they first hear about reparations, they want to say, well, if the victims are dead, if the victims already died, and if the criminals, if the political actors, if they already died, then there should be no discussion about reparations. But I do not think this is right on the basis of these legal analogies that I give you. And these legal analogies, they come from British American law. I honestly do not know if there are similar analogies in continental European law, but you can tell me. But I know that they are in British and American law. So the first analogy is compensation for wrongful death. So I give you this as an example. This happens in the United States. So suppose a man is driving a car when he is drunk. So he had a lot to drink and he is drunk and he should not be driving. He should not be behind the wheel, as we say. And suppose he causes an accident and his car hits another car and maybe several people in the other car, maybe it's a family. So I read about this a few months ago outside New York. A drunk man, he was driving a car and his car struck another car and there was a mother and 3 children. And everyone in the other car died. Everyone in the other car died. So the woman died, her 3 children died, and the woman, she was married, and so her husband loses his wife and his 3 children. Okay? The husband loses his wife and 3 children. Well, in American law, it's very common after an accident like that for there to be some compensation to in this case, the husband for the wrongful death of his wife and 3 children. And the compensation in the United States and in Britain, so it's paid by the insurance companies. It's paid by the insurance companies. And philosophically, it's interesting because many people say this. Well, they say, of course, there is no money. There's no money that could replace this man's wife and 3 children. You could give this man $50 billion, and it still would not be enough. He lost his wife and he lost his 3 children. They cannot be replaced. But the principle of law is well established. He will get some money from the driver of the car, from his insurance company, for wrongful death. So this man, he should not have been driving. He was drunk. This was an injustice. This was an injustice, and that man's insurance company must pay the man who lost his wife and 3 children. And of course, there is this possibility that the man who was driving when he was drunk, he will go to prison. That's a very serious crime, and probably he will go to prison, maybe for many years, or maybe for 10 or 15 years. Okay. A related principle is compensation for pain and suffering after certain accidents. And it could be, again, it could be like a car accident, or it could be another accident where somebody does something. So the term in British American law is negligence. So when I was a boy, I was in a car accident. And my mother was driving. But the accident was not my mother's fault. It was another person's fault, and I suffered a very serious injury. And it's a little bit funny because today is August 20th, and this accident happened on August 20th, and I still have a scar from the accident. You see this? So I broke my elbow when I was a boy in this car accident, and so I was in the hospital for about 1 week, and I did not. Obviously I did not die, and I was not close to death, but I was sick in the hospital, and I had a cast for about 2 months, and then I had to do physical therapy. So I received money from the insurance company of the other driver. Okay, so my mother was not at fault; it was the other driver, and so it's a related principle. So we say it's compensation for pain and suffering. So it could be a car accident, or maybe somebody does something in some other area of life.